Right, my name is Elton Bob. Now you can get interactive with us on our social media handles. You can follow the show with your comments, questions on Facebook, on YouTube, on X, formerly Twitter, and of course on myjoyonline.com. Let's start from the court because the Supreme Court has deferred its decision in an injunction application filed by Richard Delascar and Dr. Amanda Odo seeking to bar Parliament from transmitting the anti-gay bill to the presidency or to President Akufo-Addo for his assent. The 5-member Supreme Panel chaired by the Chief Justice in deferring its ruling indicated it will give the decision in the injunction application and the substantive application together in an expedited trial. Head of our Legal Affairs Desk, Richard Kojo, was in court and joins me in studio with details on how it went down at the Supreme Court. So Kojo, so basically today was to rule on the injunction application and to say that don't transmit the bill to the president.
So it was to indicate whether or not Parliament has the capacity to transmit this bill, which it has already finished working on, to the presidency or to President Akufo-Addo for his assent. So the last time we went to court, you know that 2 individuals, Richard Delascar, a lawyer and broadcast journalist, plus researcher Dr. Amanda Odo from the University of Cape Coast, they went to the Supreme Court seeking or praying to the Supreme Court to grant them an injunction so that it will bar Parliament, tie Parliament's hands from transmitting this bill, to that their main issue was that certain constitutional breaches were occasioned and Parliament should not even have entertained the bill in the first place because it infringes on Article 108, which states that whenever there is a bill that will be tabled before Parliament and it has a border or it has repercussion on our public purse, then it should emanate from the presidency and not from a private member. But so in this very case, it was a private member's bill, and so the Attorney General, for instance, indicated that why did Parliament not conduct any research, knowing very well that this bill will not stand the test of time, and so they were even rather shooting the legs of the entire bill so that it won't be transmitted to the presidency. And so today when we went, the court was invited to answer the question whether it will indeed grant that application that was filed by the two, but they said that they are deferring their ruling, and the reason they gave was that, in fact, some of the reliefs that were being sought in the substantive application, we have same relief or similar reliefs in the interlocutory injunction that has been filed. And so should they go on, it will not serve the ends of justice. Let's listen to the Chief Justice
in that, right.
Substantive suit together, enabling this court to deliver a more informed, comprehensive and just decision that accounts for all relevant circumstances and factors in this important matter. Such a unified approach will further provide context and clarity and also afford a clearer understanding of the issues raised in this interlocutory matter and their impact on the main suit. Having therefore diligently analyzed all the material processes on the record in this instant application and listened to oral submissions by learned counsel for the parties, our decision is to reserve our verdict on the interlocutory application until the final determination of the substantive suit, at which point we will render a comprehensive judgment that addresses all aspects of the case, including the current application for injunction. In conclusion, the decision of this court on this application for an interlocutory injunction is hereby deferred to abide the outcome of the determination of the substantive suit.
My Lord, we are grateful. Lady, I believe that is fair and equitable, and we cannot but say we are grateful. My Lord, we are also grateful.
So there was the Chief Justice delivering her ruling on behalf of the panel. So what does this mean? I didn't hear her say that we are dismissing it or we are placing an injunction on the transmitter of the bill from Parliament House to the presidency. So the space has been created. I mean, depending on how you want to interpret the court decision. But what exactly is the import of what the court did today?
So the import is that there is still an application pending that has not been determined. And so until that application is determined, and now together with the substantive application that is currently before court, so we are going to have a composite determination of this case so that they will factor the decision they would have given in this interim injunction to the substantive rate that is also currently before Parliament. So what this means is that the Parliament, the Parliament of Ghana can still not transmit the bill to the President for his assent because there is an application that has not been determined.
But the application was seeking an injunction. I didn't hear direct pronouncement on that.
Yes, so you didn't hear the direct pronouncement on that because it was deferred. They have their ruling. But until their ruling is made clear to the general public, then it means that the thing is somewhat like held in abeyance. It's just like when they had filed the application and the court had not been invited to give a decision on it. And so Parliament, as we speak now, cannot do that. So let's listen. We spoke with the Attorney General, who believes that the injunction application that was filed still holds, and they are waiting. But now it's left with some processes they would have to file, and we do not even know the dates where this substantive application, knowing very well that there is a legal vacation around.
Right.
But all of them do have processes to file until the commencement of substantive rates.
That the court things can be better dealt with in a substantive action. And it's permissible for a court to do that. There's nothing unusual at all. The court actually referred to an existing rule on injunctions. And so that, I think that the court is fair in coming by that approach. I mean, if at this stage the process have not been transmitted, and there must be a reason for that. The reason is that there was this application for interlocutory injunction pending, and the court has still not disposed of the application for interlocutory injunction. The court said the determination of that application for interlocutory injunction should abide the determination of the main case, and for that matter, it is reserving its determination until the main action is heard. It tells you that the application for interlocutory injunction is still pending, has not been disposed of, and so I think that would be the proper course to take. I still have to follow my processes, and that will be the first point for me to take. So it's a matter of complying with the rules of court. I have to comply with the rules of court first before you think about an expeditious hearing. So the question of expeditious hearing of the main case does not arise at this stage until all processes have been filed and the parties are ready to move forward. You heard counsel for the first defendant even talking about an application for consolidation that has to be made, and that has not been done. So I do not think that there's a need for us to consider the question whether.
For the injunction application, it appeared as though the AG's office did not have a position as to whether it should be injuncted or not. We were concerned about certain questions of laws being answered. Is that the same approach for the substantive case? I
think that's the main issue. I mean, the point is that the country ought to know that we're a country governed by a constitution. The constitution that prevails over everyone. We're all under the constitution and the laws of Ghana. And therefore, the actions of every person must be determined within the premises of the law. Same as a person can even question my constitutional right to prosecute in this country. We have seen that many times. Citizens of the country even file applications, the Supreme Court questioning the Attorney General's power to enter non prosecute in a certain matter and that kind of thing. And it comes up for determination in the Supreme Court. It's the same way that a decision or an action taken by Parliament can be questioned by citizens of the country. And so for me, the questions are raised during the hearing of the application for interlocutory injunction, where ones that for me have not been determined in this country, and today it has not been determined. It's the very first time that a private member's bill is, or issues regarding private member's bill are coming up for determination. Because private member's bill are quite novel. It occurred only in the time of the former parliament, the 7th parliament, headed by Speaker Professor Michael Quay. It was in his time. Of course, it was with my help as Deputy Attorney General that we all sat down, we had a roundtable conference, and then we sat down to craft ways of empowering Parliament to engender or produce its own bills. And it was in the time of the last Parliament headed by Professor Quay that the first private member's bill was passed. And really was without controversy because it did not have any implications for the taxpayer. Now, there are a lot of bills being churned through Parliament now on account of private members, which really have implications for the public purse. And I think for me, as the Attorney General of the Republic, is a question of important consideration that the court ought to really consider. Because since 1957, as I indicated to the court, since 1957, every constitution the country has had, apart from the 1961, has had provisions on Article 108, provisions akin to Article 108 in it. And there has not been any case at all filed questioning the circumstances, the ambit, or the extent to which a person can commence a bill which has implications for a taxpayer, but which do not go through the requirement of Article 108. So I think the court ought to consider such a question. And as I indicated, is a case where every person in the country ought to know that his action ought to be in accordance with the Constitution, and we all live under the Constitution of the country. And that's a country that we all seek to build. It must be in accord with fairness, and that's why we say it's a country governed by freedom and the rights of people and all that.
Right, so we are still analyzing what happened in court today. That was the Attorney General, Godfred Yeboah-Dame. You also got reaction from some of the lawyers?
Yes, so there were two. So you know that two applicants went to court. So one was Dr. Nesiawakon, and he was the lawyer for Dr. Amanda Odoi, and then Pakwesi Abedu was the lawyer for Richard Delaskai. And so after the proceedings had ended, we engaged Pakwesi Abedu, and who indicated that they were really happy because they also now have processes to file, and so they are at the feet of the court. Whatever directions the court is given, they will abide by them.
When an application is before court and it has not been determined, although it has not expressly been stated granted or not granted, but once it is pending, you don't do anything to prejudice the outcome of the application. So we say that invariably, indirectly, it is still restraining any party from doing anything contrary to the demands of the application. Can't do it insofar as this matter is pending, otherwise it will amount to contempt of court, to the best of our understanding of the law. When the court speaks about an early trial, in effect what it means is that it will speed up the process towards the determination of the matter, so that this whole issue of injunction before final determination will no longer take a center stage. As an officer of the court, I am not in the least in the position to dictate the timetable of the court. But the farthest I can say is that pleadings have not closed in the matter. As you might have rightly heard from the Attorney General, they are yet to file their response. And I believe counsel for the first defendant is also yet to file. So until those processes are filed, nobody can tell when we'll be giving date for our next appearance.
What do you make of the point for
We have always maintained that our pleading in one trajectory is different from that of the first defendant, but our case subsumes the case of the first defendant. So determining the two together will not spoil anything.
Right, so let me wrap up with Rachel Kwadwo who was in court with us today. So, Tadosori represents the Speaker of Parliament in this case. Did you get a response from him?
Well, so he usually will not give you a response outside of the court, but he also indicated that they were grateful and the necessary processes would be filed. So now all eyes are on the substantive matter. But as we speak now, we do not know when the substantive matter, because pleadings have not closed. They are still filing their processes and all of that. And we know that the legal vacation is there. So if you look at what has transpired so far, you cannot really give a definite period unless they go into their closet and then agree that this is the day that the Supreme Court has set. So we believe that the case will be listed by the Supreme Court, and that is when we will know when exactly this case will come back.
Because I heard the Chief Justice say that this case will be taken to early trial or speedy trial. It means that they are ready to proceed.
Exactly.
And that will depend on what? Exactly,
to ensure all fairness, because this application has not been determined. It should have been determined, and that is why she speaks of the ends of justice being served, so that if this one, a decision was not given, and they have to wait for the substantive matter, then it means that they need to hurry up, put a lot of things, expedited trial and an early trial, as a matter of fact, so that they can come into an early conclusion of this matter or determination of this matter, so that all parties will be satisfied with the procedure.
And there's also no indication if special dispensation will be given to this case, because the court itself is about to embark on legal vacation?
Well, so we put that question to the Attorney General that, well, now that legal vacation is on the corner, then it means that the period will extend further. Said, well, these are court processes. And so we were asking whether a special dispensation will be made so that this case will be given a particular attention. But I think we didn't really get an answer whether an expedited kind of application will be made. Exactly.
It is important because, you know, this particular bill has a life of its own. And the life of this bill can come to an end at the expiration of this particular parliament. So if this 8th parliament expires and the court hasn't taken a decision on this bill, everything parliament has done will come to a naught.
So you remember that the last time that we were in court, the Attorney General made this point that once this bill is allowed to be transmitted to the president for his assent or otherwise, it means that it cannot come back to the courts for any adjudication.
Right.
In fact, it was a bit surprising to people that do not know the process, but he says that it cannot come back to the court to cure the defect. So his argument was that the defects and the breaches that have been spotted, they need to be cured at the very, very stage where Parliament is here to transmit the bill. And so once they have cited constitutional breaches, you heard them talk about Article 108, that any bill that is sponsored to Parliament and it has some implications on the finances of the country, then it means that it should emanate from the presidency.
Yes.
But this time, it is not emanating from the presidency, but private members. You know that this issue about private members, it surfaced in court during the last parliament, the 7th parliament,
Yes.
but that one did not have financial implication on our purse. And so that is why we didn't really hear about the hullabaloo about this one. But this one, because it is a border on the consolidated fund, that is why it has become an issue.
Right, Kojo, thank you so much for it. We're keeping an eye on this matter. As we speak right now, even though Parliament has passed the anti-LGBTQ bill, the bill is still sitting in the office of the clerk to Parliament because there's a legal challenge. The clerk cannot transmit the bill from Parliament to President Akufo-Addo for his assent because the court will have to make a determination whether or not Parliament breached certain, aspects of the Constitution when they consider this private members' motion, or whether or not they operated within the confines of the law. That is the determination the court must come to before we will know the next stage of this. We're keeping an eye on this matter, bring development on this. But let me move away from the court because it's been revealed that there is heightened dissatisfaction among the youth in Africa in democratic governance. These findings from the latest Afrobarometer report further shows that the youth have been left at the bottom when it comes to decision-making in governance, stirring the agitations that we've seen in recent time. Now, recent development led to public uproar of Generation Zs in Kenya who took to the streets to demand inclusive governance. Director of Survey at Afrobarometer, Boniface Dulani, who made this observation, however, said pragmatic measures should be implemented to avert Kenya-like situation in Ghana because there is a dip in its democratic scorecard.
It's true that the youth, I think, are more dissatisfied with the democracy, and they also are more inclined to support authoritarian forms of government, especially military rule. I think part of the problem here and the challenge, especially for the youth, is that when you also ask our respondents, what are the most important things that they want the governments to be addressing? And unemployment is, I think, a big problem, and especially for the youth. So they are looking at alternative forms of government that can help to deliver on their needs and especially on creation of jobs.
Right. So is it the case that, per your report, the governments are not doing enough to address these challenges, a reason they seem not to have any hope for their countries?
It is a part of the problem. It's one, I would say, of many problems. Of course, the youth are looking at a lot of things in terms of government service delivery, including, I think, less corruption. They also feel that the politicians are not delivering on their needs, as already highlighted. So the youth are looking at representatives so that they can best represent them. And when you see from the results, one of the challenges that the youth are highlighting is the fact, not just the youth, but most Africans, is that the elected leaders are not doing a good job to advance their own interests. So there is a disconnect between what the people want and what the governments are prioritizing.
So is the African situation a reflection of what happened in Kenya, where the Generation Z had to flood the street to demand inclusive governance?
Of course. I mean, if you see that the governments are not, and government and elected leaders are not representing your interests, the next step is that the people take it upon themselves to make sure that they go to government and that the government should hear from them directly rather than our elected representatives.
Let's look at specifically to the countries. You made mention that some countries are seeing a dip in democratic scorecards, specifically Ghana. Tell us what the situation actually is on the ground.
Well, of course, I mean, this is a very big continent, so as the report highlights, there are differences from country to country. Some of the countries like Ghana, we've seen a huge drop in satisfaction with democracy. And I think the reasons, as we know many of them, the economic situation in Ghana in recent years has not been particularly great. The youth have, as I've already said, like their colleagues elsewhere, are not happy with the amount of jobs that are being created. So most youth are going to attend higher education, and then when they complete higher education, you find that there are no jobs to absorb them. But they are also really disillusioned by the high levels of corruption. So on one hand, governments are telling the people that, look, brace up for these tough times, but then they look at the political leaders are not themselves really demonstrating that they too want to live that kind of life that they also sacrificing.
So what should be done immediately?
I think it is important that governments really listen to the voices of the people, and that's what Afrobarometer is trying to do, to make sure that the voices of ordinary citizens are heard. Because if governments don't listen to the people, then either the next thing is that the people will vote out the governments, or as we've seen, I think people will be looking at alternative forms of government. What I think the report highlights is that while people remain committed to democracy, they are not happy with the democracy that is on offer. And these two sides, right now, I think we're saying that support for democracy is holding steady. But as more time passes with the disillusionment with the democracy, then more and more people will get disillusioned with the democracy itself, and then they will start to look at alternative forms of government.
Now, we'll see a little longer on this matter because Dr. Chifundo Kachali, the immediate past Electoral Commissioner for Malawi, warns that the findings from the report should not be taken lightly and advise the Electoral Commission of Ghana to be more transparent in its operations to prevent suspicions going into the December 7 general elections.
Well, I do believe that, speaking for our Malawi Electoral Commission, we did have a very strong civic and voter education mandate, and we took full advantage of that to make sure that we engage the youth. So we undertook some public lectures on different institutions like university lectures and also in other public squares to ensure that we can create a platform where the youth are actively engaged and their issues are vented out, but also where they're given an understanding of why their civic agency is very critical to ensuring that they remain engaged in the political processes, because I think the tendency for the youth is to adopt a protest approach when they're disgruntled, instead of making sure that they're getting integrated into the political structures where they can push forward their own candidates who pursue their agenda, and that they should recognize that because of the demographics, I don't know, Ghana may not be different to Malawi, for example, where the numbers for the youth are very high. And that means that if they mobilize well and support a certain platform, they do have a very strong opportunity and agency to actually reform and transform the political landscape. So we have an experience where we believe that engagement with the youth to just highlight the different opportunities they have to make a difference in the political landscape is more instrumental proactively, instead of waiting for things to go wrong and then they come at the end and start protesting.
In the wake of this, Ghana has 5 months to the elections. You have been in that hot seat before. You have just ended your tenure in Malawi. What is your advice to your counterparts in Ghana so far as these public sentiments are concerned going into the elections?
I think as election management body, it's always important to remember that credibility credibility is very important. So everything you can do to ensure that you create a level of confidence in the stakeholders about the integrity of the processes that you're managing can never be underestimated. And one of the ways to do that really is just being transparent and open about everything you're doing. Sharing information, and people should be aware of what's going on and why things are happening a certain way, removes suspicion, because where there's too much suspicion, it gives rise to a lot of conspiracy theories. Where there's transparency and accountability, people have information to actually make informed decisions.